Please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. All right. So today we heard from the judge in the Letitia James case as well as the James Comey case. And that judge did what many of us expected him to do, which is he dismissed the indictments against both of those people. All right, against Letitia James and James Comey, former director of the FBI, James Comey, and the current Attorney General of the state of New York. So the judge said, no, not letting this happen. I'm going to put a stop to this. We can't do this. We got to rectify this. And of course, the Trump administration pushed back vigorously, but the judge said, nah, we can't do this. We gotta dismiss both of these indictments. All right. Now let me tell you this: the dismissal is without prejudice. Without prejudice. What does that mean? That means that they can seek another indictment against both of them. All right. Had it been with prejudice, then that would be over. It would be over. They couldn't go back to the grand jury and try to get another indictment. But it is without prejudice. So they can and most likely will impanel another grand jury and ask that grand jury to indict these two people again. Now, another caveat is that, I guess before I go over that, and I don't want to jump ahead of myself because I want to read some of this case, but let me just say this. The judge did not dismiss the case on the basis of selective prosecution or malicious prosecution, okay? That was not dealt with here in this dismissal. The selective prosecution issue will be dealt with at another time. I think it will happen too pretty soon, okay? Pretty soon. And the selective prosecution has to do with the fact that these folks are targeted because Trump is basically retaliating against both of them for various reasons. All right, so that's not at play either. All right, so this is about the unconstitutional or illegal appointment of Lindsay Halligan. All right, that's what this is about. And we're going to look at what happened here and why the judge did what the judge did. Okay. So let's get into reading a little bit of this case. It's very fascinating, very interesting, at least for me. As an attorney, I'm constantly reading legal documents, and I love what I do, so I enjoy it. Sometimes I kind of geek out, on the law, quite frankly. All right, let's go to another screen here. I got the dismissals put up here. Let me also see if I can pull up your comments. I would love to see your comments. Okay. Would love to see and address some of your comments. So let's see here if I can pull it up. Yep, I do see them. So let me just shout some of you out. Thank you for tuning in. Can't pronounce some of this. Brad Patterson, thank you for tuning in. Who else? Lindsay. I'm sorry, Tamrin. So she said here, I am I pronouncing this correctly? Am I pronouncing this correctly? I don't know. I can't see some of your names here, but somebody asked, I thought the prejudice part was just for Comey, not James. That's why we're going to read this here. Audible video, which is greater, the incompetence or the criminality? You know, that's a good question right there. That is a very good question. Let's see. Somebody said hallelujah. Yes, hallelujah. Okay. So let's read some of this. And it says on October 9th, 2025, Lindsay Halligan, a former White House aide with no prior prosecutorial experience, appeared before a federal grand jury in the Eastern District of Virginia, having been appointed interim U.S. attorney by the Attorney General just 2 weeks before. Ms. Halligan secured a 2-count indictment charging New York Attorney General James with bank fraud and making false statements to a financial institution. Ms. James now moves to dismiss the indictment on the ground that Ms. Halligan, the sole prosecutor who presented the case to the grand jury, was unlawfully appointed in violation of 28 U.S.C. Section 546 and the Constitution's Appointments Clause. As explained below, I agree with Ms. James that the Attorney General's attempt to install Ms. Halligan as interim U.S. Attorney for the Eastern District of Virginia was invalid. And because Ms. Halligan had no lawful authority to present the indictment, I will grant Ms. James' motion and dismiss the indictment without prejudice. So Ms. James' motion and the dismissal, the motion was granted and the judge dismissed the indictment without prejudice. So they can bring another indictment. Now, there is some issues, right? Because the first time when they tried to indict Ms. James, the sitting U.S. attorney wanted no parts of it. And so rather than go through with the indictment, he, in fact, resigned. The judge talks about that in the opinion. And that's when they hurriedly got Lindsay Halligan in the office, and she is the one who secured the indictment. And wow, the appointment, the judge said, was unlawful. All right, so here's some of the legal background here. The Appointments Clause prescribes the exclusive means of appointing officers of the United States. The text of the clause contemplates 2 types of officers: principal and inferior officers. Principal officers must be appointed by the president with the advice and consent of the Senate. The same process is also the default manner of appointment for inferior officers. But the framers recognized that requiring all officers of the federal government to run the gauntlet of presidential nomination and Senate confirmation would prove administratively unworkable. So, on one of the last days of the Constitutional Convention, they authorized an additional and streamlined method of appointment for inferior officers in the final provision of the Appointments Clause. That provision sometimes referred to as the accepting clause. All right. It permits Congress to, by law, vest the appointment of inferior officers in the president alone, in the courts of law, or in the heads of department. The United States attorneys, Congress has preserved the constitutional default rule of presidential appointment and Senate confirmation. Let's scroll up. Congress has also established a mechanism set forth in 28 U.S.C. Section 546 for appointing interim U.S. attorneys when a vacancy arises. Section 546 essentially divides the responsibility for making interim appointments between the Attorney General and the district courts. It provides in full. All right, now listen, this is the statute here, okay? This is the statute. All right, except as provided in subsection B, the Attorney General may appoint a United States attorney for the district in which the officer of United States attorney is vacant. The Attorney General shall not appoint as U.S. attorney or United States attorney a person to whose appointment by the president to that office the Senate refused to give advice and consent. Okay, so the Attorney General can make that appointment pursuant to this particular statute, right? Can't appoint anyone, though, that the Congress, that the Senate has rejected. All right, subset, small letter C, a person appointed as United States attorney under this section may serve until, and this is really important right here, until the earlier of. So whatever comes first. Number one, the qualification of a United States attorney for such district appointed by the president under Section 541 of this title. So if the president appoints someone, then that's it, okay? That interim appointment ends at that point. Or the expiration of 120 days after appointment by the Attorney General under this section. So whichever of those two provisions occurs first, all right? Whichever one occurs first. If an appointment expires under subsection C2, the district court for such district may appoint a United States attorney to serve until the vacancy is filed. The order of appointment by the court shall be filed with the clerk of the court. All right? So after that interim period is up, then the judges are the ones who will do the appointing if no U.S. Attorney has been appointed by that time. All right, and appointed and with the advice and consent of the Senate, essentially. All right, factual background. On January 20th, 2025, Jessica Aber, who had been nominated by President Biden and confirmed by the Senate, resigned from her position as U.S. Attorney for the Eastern District of Virginia. The following day, and that's pretty typical, if you're appointed by one president, typically the other president, the incoming president, want his or her own U.S. attorneys across the country. So that's sometimes they keep them on, but that's pretty typical. All right, so she resigned. The following day, the Attorney General appointed Eric Siebert as interim U.S. Attorney under 28 U.S.C., Section 546. So that means ordinarily, Mr. Siebert would have 120 days. All right, 120 days to serve in that position since Attorney General Pam Bundy appointed him. All right. Mr. Siebert's 120-day interim appointment was set to expire on May 21st, 2025. So on May 9th, 2025, the judges of the district exercised their authority under Section 546D to appoint Mr. Siebert to continue in his role effective May 21st. On September 19th, 2025, Mr. Siebert informed colleagues of his resignation. According to news reports, Mr. Siebert had recently expressed concerns to senior Department of Justice officials about the viability of pursuing charges against Ms. James and former FBI Director James Comey. Mr. Siebert's resignation came hours after President Trump told reporters at the White House he wanted Mr. Siebert out. So that was basically the end of his appointment. Okay? If the sitting president wants you out, then you pretty much are out. You serve at the pleasure of the sitting president, right? If he no longer has pleasure in your appointment, then you're probably out of there. The next day, President Trump posted and later deleted the following message on social media. Now, this message goes to the heart of the selective prosecution part of this whole thing. All right, and I think it's pretty strong, quite frankly. I think it makes their case for selective prosecution pretty strong if the DOJ secures another indictment. Pam, I have reviewed over 30 statements and posts saying that essentially, same old story as last time, all talk, no action. Nothing is being done. What about Comey? Adam, Shifty, Schiff, Letitia. They're all guilty as HELL, but nothing is going to be done. Then we almost put in a Democrat-supported U.S. attorney in Virginia with a really bad Republican past. A woke rhino, Republican in name only, who was never going to do his job. That's why two of the worst Dem senators pushed him so hard. He even lied to the media and said he quit and that we had no case. No, I fired him, and there's a great case, and many lawyers and legal pundits say so. Lindsey Halligan is a really good lawyer and likes you a lot. We can't delay any longer. It's killing our reputation and credibility. They impeached me twice and indicted me 5 times over nothing. Justice must be served. Now, President DJT. I mean, that makes a really strong case for selective prosecution. Really, really strong case. All right? Less than 48 hours after President Trump's post on September 22nd, 2025, the Attorney General issued an order authorizing Lindsey Halligan to be the interim United States Attorney for the Eastern District of Virginia during the vacancy in that office. The September 22nd order cites only 28 U.S.C. 546 as the basis for Ms. Halligan's appointment. So her appointment was not based on the advice and consent of the Senate. I don't think the president had even nominated her. So on October 9th, 2025, a grand jury sitting in the Eastern District of Virginia returned a 2-count indictment against Ms. James, charging her with bank fraud in violation of 18 U.S.C. 1344, making false statements to a financial institution, in violation of 18 U.S.C. 1014. The charges, you can't see this, I don't think. Let me push it up. The charges stem from allegations that Ms. James falsely claimed that she would use a Norfolk, Virginia home as a secondary residence to secure a more favorable mortgage rate. Ms. Halligan was the only prosecutor who participated in the government's presentation to the grand jury, and only on her signature appears on Ms. James, indictment. Wow. Wow. I've looked at many indictments over the years, hundreds, if not thousands. And, different states do it differently. Federal government has its way of doing things, but never just the prosecutor. Never just the prosecutor. All right, procedural history. Procedural history means what happened in the court, what documents were filed, what orders were signed, what motions were filed, and so forth. That's what he means by procedural history. On July 24, 2025, Ms. James moved to dismiss. In other words, she filed a motion to dismiss the indictment on the ground that Ms. Halligan's appointment was unlawful under Section 546 and violated the Appointments Clause. Later that day, the Honorable James K. Walker transferred Ms. James' motion to me pursuant to an October 21st order issued by Honorable Albert Diaz, Chief Judge of the United States Court of Appeals for the Fourth Circuit. The Fourth Circuit is one of the courts of appeals. It is over Virginia, North Carolina. It's in that part of the country. My old stomping grounds. Chief Judge Diaz had designated and assigned me to sit in the Eastern District of Virginia for the limited purpose of hearing and determining motions concerning the appointment, qualifications, or disqualifications of Ms. Halligan or the U.S. Attorney's Office. Finding it necessary to determine the extent of Ms. Halligan's involvement in the grand jury proceedings, I ordered the government on October 28th to submit for an in-camera review, which means in my chambers or in the judge's chambers, an in-camera review of all documents relating to Ms. Halligan's participation before the grand jury, along with complete grand jury transcripts. Judge likely did that because grand jury transcripts, it's hard to get those. Most of the time when we request grand jury transcripts, most of the times we don't get them. We have to really fight for them, and the prosecutor tends to fight vigorously against you receiving the grand jury transcripts. But, there are times when you can get them. On October 31st, I received the pretrial transcript containing only Ms. Halligan's presentation of evidence and witness testimony. Subsequently, on November 6th, the government provided a complete transcript of the proceeding, which included Ms. Halligan's opening and closing remarks. Okay. On November 3rd, the government responded in opposition to Ms. James' motion, of course. Also that day, the government filed an order for the Attorney General or from the Attorney General dated October 31st, 2025. Attorney General order number blah, blah, blah. The order, the October 31 order reads in its entirety. On September 22nd, 2025, I exercised the authority vested in the Attorney General by 28 USC Section 546 to designate and appoint Lindsay Halligan as the United States Attorney for the Eastern District of Virginia. For the avoidance of doubt as to the validity of that appointment and by virtue of the authority vested in the Attorney General by law, including 28 USC Sections 5.9, 5.10, and 5.15, I hereby appoint Ms. Halligan to the additional position of Special Attorney as of September 22nd, 2025. I don't want to get into the weeds too much here, but I think it's, again, I'm subject to sort of geeking out here. And thereby ratify her employment as an attorney of the Department of Justice from that date going forward. As Special Attorney, Ms. Halligan has authority to conduct in the Eastern District of Virginia any kind of legal proceeding, civil, criminal, including grand jury proceedings and proceedings before United States magistrates and judges. In the alternative, should a court conclude that Ms. Halligan's authority as special attorney is limited to particular matters, I hereby delegate to Ms. Halligan authority as special attorney to conduct and supervise the prosecutions in United States versus Comey and United States versus James. In addition, based on my review of the grand jury proceedings in United States versus Comey and United States versus James, I hereby exercise the authority vested in the Attorney General by law, including 28 U.S.C. sections 509, 510, 518B, to ratify Ms. Halligan's actions before the grand jury and her signature on the indictments returned by the grand jury in each case. So, Ms. James, again, this is the procedure history, so all the filings and so forth up to this point is what he's sort of covering here. Ms. James filed her reply on November 10th. On November 13th, I heard oral argument from the parties and took the matter under advisement. During the hearing, I raised concerns about the Attorney General's ability to review Ms. Halligan's presentation to the grand jury in United States versus Comey, when, as of October 31st, the government had not yet received the complete transcript of the proceeding. My questioning prompted the government to file a new ratification order from the United States, from the Attorney General, in this case on November 17th. In that order, the Attorney General stated she had reviewed the entirety of the record now available to the government and again ratified Ms. Halligan's actions before the grand jury in her signature on the indictment. Okay, let's jump down. This is the discussion. This is the judge's thinking and his applying the facts to the law here. This is a 20, I think it's 26 pages. This can get a little dense, so we're not going to try to read all of this, but let's read some of it. Resolving Ms. James' motion requires me first to decide whether Ms. Halligan was validly appointed as interim U.S. attorney under Section 546 and the appointment clause. If the answer to that question is yes, I need not go any further, and Ms. James' motion must be denied. But, and judges do that all the time, if they resolve the first issue, quite often they don't even get to the second issue. All right, you see it all the time. Having resolved issue one, the court has decided not to or doesn't need to resolve issues 2, 3, 4, 2 through 10 or something. Happens all the time. One or two of my law professors would say it's like they get lazy. Okay, they just don't want to go further with it. Because, I mean, the real reason is because resolving the first issue is dispositive, right? It disposes of the case. And what's the point of going any further if the first issue is dispositive? Okay. So the judge concluded Ms. Halligan's appointment violated Section 546. And really, on that basis, the judge dismissed the indictments. Okay? Just based on that. A little bit of what he said. According to the government, this case is simple. In its view, the one and only limitation on the Attorney General's authority to appoint interim U.S. attorneys under Section 546 is subsection B, which bars the Attorney General from appointing anyone whom the Senate has refused to confirm. Nothing in the text, it continues, explicitly or implicitly, precludes the Attorney General from making multiple interim appointments during a vacancy. Thus, it concludes, because the Senate has not refused advice and consent to Ms. Halligan, the Attorney General lawfully appointed her as interim U.S. Attorney on September 22nd. Ms. James counters that Section 546 vests the Attorney General with 120 total days to appoint an interim U.S. attorney. After that period, the exclusive authority to appoint an interim U.S. attorney belongs to the district court. Now, that's the way I read the statute as well. Okay, that's what it says. That's what we read earlier. Right? 120 days, whatever comes first. If the president is able to get somebody confirmed before the 120-day period, then fine. But if not, then the 120-day will expire, and then the judges have to appoint the interim U.S. attorney. So I read it the exact way that Ms. James read it, because that's what the statute actually says. Now, let me say this about the practice of law. Just because a statute has a very plain meaning, right? It's very clear. That doesn't mean that is the actual interpretation of the statute. And so what you have to do is you have to do a study of case law to see how judges have interpreted that statute. All right? The judges may reach a completely different conclusion about what it means, what a statute means, what a word in the statute means, what a phrase in the statute means. So you just can't read a datute and it seems to be plain on its face, and you run off with thinking you know what it means. No, we don't do that. We then go to the case law, right? There are hundreds of thousands of cases, I guess. And it's the reason why we keep a subscription to one of the companies that has all these cases indexed and cataloged, like LexisNexis or Westlaw. We have to keep that prescription so that we can research many things, including what a statute, how a statute has been interpreted. Okay? All right, so Ms. James counter, did I read that already? Yes. All right, so the last sentence in that paragraph, she says, therefore, she argues Ms. Holligan's appointment was unlawful because the Attorney General's appointment authority expired on May 21st with the end of Mr. Siebert's 120-day term. Ms. James has the better reading of the statute. So the judge says, I agree with Ms. James. Okay? And it's on that basis that the judge dismissed the indictments. All right? Let me pull up one other thing here. The judge says Section 546 is unambiguous. It is. I mean, it's pretty plain on its face. But caution again, if you ever go to law school and become a lawyer and so on, you'll remember this, that you don't run off with your interpretation. You see what the judges have said. And he being a judge, I'm sure his clerks, right, researched to see what other judges said, and he felt comfortable saying, well, this is not ambiguous. Subsection A begins by authorizing the AG to appoint U.S. Attorney for the district in which the office of the United States Attorney is vacant. Yes. So, I mean, he just sort of lays out, again, his rationale there. And there's no point in us going through all of that. Okay. So what I'm going to do is jump to the very end here where the judge writes his conclusion, his His final conclusion. All right. For the reasons set forth above. Okay, hold on. Okay, I think someone had mentioned earlier, I believe, whether this was with or without prejudice. So here we go. Let's read that little section. Dismissal will be without prejudice. All right, having found that Ms. Halligan's appointment violated 28 U.S.C. Section 546 and the Appointments Clause, and that dismissal of Ms. James' indictment is warranted, the remaining issue is whether dismissal should be with or without prejudice. Ms. James' motion does not specifically request dismissal with prejudice. The government argues she has thus forfeited the request. In her reply brief, however, Ms. James urges me to exercise my supervisory powers and dismiss her indictment with prejudice so they can't bring it back. A with prejudice dismissal is necessary, she argues, to promote the interests protected by the Appointments Clause and to deter the government from deploying unlawful appointments to effectuate retaliation against perceived political opponents. Ultimately, I believe the Supreme Court's Appointments Clause jurisprudence provides the answers to the with or without prejudice question in both Ryder and Lucia. All right, you see the judge is doing exactly what I told you. So he's going to the case law. The court essentially unwound the actions taken by the unconstitutionally appointed officer and restored the affected party to the position the party occupied before being subjected to those invalid acts. Okay. Trying to get past all the case law and just read the judge's thinking here. So the judge goes on to say, I will do the same. I will invalidate ultra-virus acts performed by Ms. Halligan and dismiss the indictment without prejudice, returning Ms. James to the status she had before the indictment, basically. Okay, so it is without prejudice. She would have certainly wanted it to be with prejudice, right? So almost the first thing we look at when we get, and that with or without prejudice is not just in criminal cases, but also in civil cases. We filed suit against someone not so long ago, and we were able to get it resolved. And we requested when we agreed to dismiss the case, we requested that the judge in the case would, in fact, sign the judgment without prejudice so that we could refile if the other side didn't keep their end of the bargain. Okay? So it's really important. It's really, really important. So the conclusion, for the reasons set forth above, it is hereby ordered and adjudged as follows. And by the way, I am, I've been really, really laser focused on Letitia James, more so than Mr. Comey. Miss James is the one that, I've just been keeping up. I've done multiple videos for her situation. All right, for the reasons set forth above, it is hereby ordered and adjudged as follows. The appointment of Ms. Halligan, I don't know if it's Halligan or Holligan, however you want to say it. The appointment of Ms. Halligan as interim U.S. Attorney violated 28 U.S.C. Section 546 and the Appointments Clause of the United States Constitution. All actions flowing from Ms. Halligan's defective appointment, including securing in signing Ms. James' indictment were unlawful exercises of executive power are hereby set aside. The Attorney General's attempts to ratify Ms. Holligan's actions were ineffective and are hereby set aside. Ms. James' motion to dismiss the indictment is granted in accordance with this order. The indictment is dismissed without prejudice. Ms. James' request for an injunction barring Ms. Halligan from participating in the prosecution of the case is denied as mute. The power to appoint an interim U.S. attorney for the Eastern District of Virginia pursuant to 28 U.S.C. Section 546 during the current vacancy lies with the district court until a U.S. attorney is nominated by the president and confirmed by the Senate under 28 U.S.C. Section 541. So that last little paragraph there is important because the judge said that they cannot, A.G. Bondi cannot appoint another interim U.S. attorney. The judges are going to have to do it pending Trump nominating someone in the Senate with advice and consent confirming that person. So until then, the interim U.S. attorney for the Eastern District of Virginia has to be someone that the judges in that district select. All right. So I still think, however, that they're going to try to get another indictment. There is, until double jeopardy attaches, they can go back and forth and panel as many grand juries as they want. I've seen prosecutors impanel 5 or 6 grand juries because they're so intent on indicting and prosecuting someone. So yes, I'm sure Ms. James would have preferred that this was with prejudice. But as I said in the beginning, I think that she has a very strong case where selective prosecution is concerned, just based on the thing that the tweet or whatever you call it from Trump's Social Truth or Truth Social account. All right. I think she has a strong case. I don't know what the judge would do in that case if when that comes before. I believe that's with another judge. Maybe I can't. I'm not sure. But whoever is listening to that, I do believe that Letitia James especially, and Comey, because Trump literally names them. He names them and orders the AG to bring the case, the indictment. All right. Okay, so I'm reading some of your comments here. Oh, okay. So we're back to whether it was with or without prejudice. As we clearly see here, Letitia James' indictment was dismissed without prejudice. James Comey is not covered. We don't see that here. So we, I dealt with, as I said, I've been laser focused on Letitia James. Okay, I've not done one video on James Comey, so I don't know what's really going on with him. I've been laser focused on the sister from Bed-Stuy, Brooklyn. Okay, place I used to live many years ago. I think this is a really good question from Audible Video, though, which is greater, the incompetence or the criminality? That's a very, very good question there. I'm looking at some of your comments. Someone said it should have been dismissed with prejudice. Well, the judge went through several cases explaining why he did so without prejudice. And keep in mind, both sides can actually appeal, right? So there may be some more procedural history here before it's all said and done. Will there likely be a bar review on Holligan? I don't know if there would. I don't know. I would be purely speculating. Um, Typically, bar reviews have to do with whether or not there's some unethical behavior, not just making a mistake. Everybody make mistakes. She was very inexperienced in that position. So just making a mistake, Lord, if we were all referred to the bar for a mistake, now, of course, we have to give competent representation, right? So there is a duty. It's not like I'm, saying that you can just be an inept, incompetent lawyer. Yeah, I mean, that can get you reviewed by the bar. But a mistake where there was no illegality or it wasn't unethical, and you did your best. You studied, you provided the best representation to your client as possible. I mean, they still can refer you to the bar, but hopefully the bar would see that this was not, something that deserves some sort of sanction or something. Just depends. Just depends. Okay. I've gotten to the end. Someone said this may show, Mr. Patterson said, signify, no, slightly sunny in the ATX. I'm sorry, this text up here is really small. ATX, is that Atlanta? Is that Atlanta? Maybe showing my ignorance. I don't know some of the lingo today, but is that Atlanta? And he also asked, is it a permanent ruling? No, it's not permanent because it can be appealed. And again, because it's without prejudice, they can bring it, they can try to get another indictment. I predict they will. And this is a question that, by the way, that no one asked, but it's a great question. What about the statute of limitations? What about the statute of limitations? No one asked this. No one asked this. What about the statute of limitations? Okay. So, before I end this, let's answer that question. It's a very good question. What about the statute of limitations? Because if the statute has expired, then they can't bring it back. If the statute is gone, if the statute has told. So let me see if I can pull this up and answer that question. It's a very, very, very important question. Very important question. Okay, so let's go back to the other screen. Okay. Statute of limitations. A new indictment filed after an original indictment has been dismissed and the limitations period has passed is governed by 18 U.S.C. S. Section 3288. That statute permits the government to refile the indictment within 6 months after the original indictment is found to be defective. But as with the filing of a superseding indictment, a new indictment filed under Section 3288 may not broaden or substantially enlarge the charges of the original indictment. I think there's another section here. Let's say. I thought there was another section. Is there another section? Yeah, here we go. An indictment charging a defendant with a federal non-capital crime generally must be returned within 5 years after commission of the offense. So, generally, 5-year statute of limitations. Once an indictment is filed, the limitations period is told. That means stopped. All right? It is stopped once that indictment is filed. Okay? A superseding indictment that is filed while the original indictment is pending will relate back to the original indictment and therefore also be timely unless it broadens or substantially amends the charges. Relate back means that it will go back to the date that the original indictment was filed. Okay, that's what it means to relate back. But then it goes on to say, however, a new indictment filed after an original indictment has been dismissed and the limitations period has passed is governed by 18 U.S.C. S. Section 3288. That statute permits the government, and this is the part here, to refile the indictment within 6 months after the original indictment is found to be defective. So, the answer to the statute of limitations question is, since they filed the first indictment within the statute of limitations, that told it, that stopped the statute of limitations. Now, after the judge has, subsequently to the judge dismissing the original indictment, they have 6 months. So the statute of limitations is not a problem. Neither is it a problem since the dismissal is without prejudice, which is why I believe that they will seek another indictment. You know, the problem they had, though, I think is still a problem, which is most of the experienced U.S. attorneys and assistant U.S. attorneys, they didn't want anything to do with this. And that's why they brought in Miss Holligan. The experienced folks, like, no, this is not something that we want anything. No, nope. So they may have that problem again, but I'm sure they can find somebody. I'm sure they can find somebody. All right, so this is probably not the end of the case. And again, keep in mind that either side can appeal. So the Trump administration can appeal this dismissal. All right? Okay, so let's end it here. Thank you for joining. And this is Thanksgiving weekend. It's a very important weekend. I love it. This is my favorite time of the year. Thanksgiving, all the good food, the family, the football. Man, football. Speaking of football. Yesterday was a pretty exciting day. I intend to do a video on some of the things that happened yesterday, so I'm not even going to get into it, okay? I'm not even going to get into it right now. But I think the next video I do will be football. All right, that's the end. Again, thank you all. If I don't speak to you again, please enjoy your Thanksgiving. Bye.